Welcome to the Citi Cares Small Business Academy, presented by Citi Trends and the law firm of Seyfarth Shaw. In this 6-episode series, we explore what it takes to start a successful business designing or manufacturing products for retail sale. This presentation has been prepared by Citi Trends and Seyfarth Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. Welcome to the 5th session in the 2021 Citi Cares Small Business Academy. No copying, the basics of intellectual property. Our presenter today is Seyfarth Bajanki of the law firm Seyfarth Shaw.
Well, thanks everybody for attending today, and I'm here on behalf of Seyfarth Shaw, and this presentation is about intellectual property for the Citi Cares Small Business Academy. My name is Seyfarth Bajanki, and I'm based here in our Houston office of Seyfarth Shaw. So this presentation is going to cover all of the main types of intellectual property, including trademarks, copyrights, and patents. And I like to view this as sort of an intellectual property 101. So we're going to get all the basics, key concepts, and also explain with examples how they operate practically. Next slide, please. We are going to look at all the different key concepts here of IP. And the good news here is that if you have a business, you probably have some IP already. Hopefully after this presentation, you're going to be able to speak some of the lingo here about IP, that it's going to make it a lot quicker and a lot easier for you to think about what you have, how to protect it, potentially how to enforce it, and also how to speak to an IP lawyer and know exactly what to ask. Next slide. So this is our agenda slide. We're going to return to this a lot of different times here because this is a chart that just gives an overview of all of the different kinds of IP. Typically, we have about 4 types of IP. So you can see them on that left-hand column: trademarks, copyrights, patents, and trade secrets. And each of the columns give you what does it protect, and then some real life examples, and then also a legal budget to acquire. So we're going to go through all the different concepts and talk about all these things throughout the whole presentation. We are going to add one more column though, which I'm excited to reveal. So we go to the next slide. Introducing my new product, the Cobb Buddy. I'm from Iowa and Illinois originally, and we know corn, and this is a completely fake and made up product that I'm going to use for demonstration purposes here to talk about IP. To grill corn in hot summers, like we have in Iowa and Illinois, and where I'm from right now, which is Houston, Texas. It's made of durable food grade metal, although it kind of looks like wood there, but believe me, it is metal. It's got easy to grip handholds, which also are a bit difficult to see. The skewer, importantly, as we'll talk about with the patent and trade secret context a bit later, the skewer turns yellow when the corn is done. So when you're grilling the corn, oftentimes it's difficult, especially for me, to know when it's perfectly done. It's not burnt, and it's not too dry, and it's certainly not raw, and the skewer magically turns yellow. So next slide. So let's talk about trademarks 101 first. The key concept here is the difference between a common law trademark and a registered trademark. And before we get too deep into this, I did want to talk about clearance. So we're going to talk about how you acquire one, but acquiring a trademark is different than somebody else owning one before you and being able to enforce their trademark against you. So you could acquire one, but that doesn't mean, it never means that you won't get a lawsuit in the mail because someone else has a trademark. So I did want to point that out. Consider a basic clearance search, and we'll talk a bit more about that in the next slide. But first, let's go to common law trademarks on the left hand there. What is common law? Common law is simply that there's no real federal statute describing how the trademark works or is acquired. Common law is typically referred to as state or local law. It's real easy to get a common law trademark. Simply start using the mark in commerce. So the first time you go and offer to sell it, in this example, Cobb Buddy, go out and offer to sell Cobb Buddy and put a big Cobb Buddy stamp on it, you've got some common law protection. It may not be a lot, but then the more you do that, the more common law protection you'll have, and the easier it will be to enforce that trademark. Some people, you'll notice in the lower left there, we've got that designation TM. You can put TM up at the top of your common law mark when you start using it, and there's no real regulation about that. Usually what I find is it's a matter of preference and marketing preference for startups. So typically what you see when I explain, well, hey, you can use TM there because you're offering your product, that some people get excited and say, yes, I'm going to go ahead and do that. Some people say, nope, that doesn't really work with my marketing strategy. I'm going to wait till I've got a registered trademark. And that's over on the right side of this slide. To get a registered trademark, well, who's it registered with? It's registered with the U.S. Patent and Trademark Office. So you've got to file an application, and you can register words or a logo plus words. Rejection is possible. So if there's an earlier mark out there, it can be rejected. The process is usually takes between 12 and 18 months or so. And it's, as we've seen in our chart, and we'll go back to, the cost is on the lower end in terms of IP. So it's a good option. And you can see there in the lower right, there's the R with the circle on it. So after you have the registered mark, you can put that R in a circle. So we'll go to the next slide. Here's an example of what enforcing a trademark looks like. And the test here, the real easy test to see if you're infringing somebody else's trademark is if there's a likelihood of consumer confusion, and also who was first. So if somebody was first, that person will have superior rights, or that company will have superior rights typically. Let's look at an example here so I can explain how likelihood of consumer confusion works. So Cobb Buddy, we've got our mark there on the lower left. That's my logo. It says Cobb Buddy on it. At the top, I've got the logo plus the word. At the bottom, I've just got the word mark. Let's look at our competitors. At the very top, we've got Veg Buddy, and it's a little more general than corn. Now, would a consumer, if they were looking at the logo on the top and comparing that to the Cobb Buddy logo, would that really confuse them? It's different colors, it's different shapes. The photograph seems very different. Broadly, it's the same kind of grilling accessory, but I would suggest there isn't too much similarity there. Let's take the second example, corn cob friend. Now, would a consumer be confused if they saw corn cob friend in words, regardless of whatever the packaging was, or all held equal, corn cob friend versus Cobb Buddy? Maybe that's a bit of a closer call. How much time are these consumers spending when they're going to buy grilling accessories? Maybe it's just 10 seconds. They just grab it and go. Oh, corn cob friend sounds similar enough. That must be the same as Cobb Buddy, and boom, you've got a purchase, and potentially you've got an infringing use there because so many consumers may be confused by it. Maybe they're sold in the same aisle too. Let's look at the next one, griller corn. So that's got that similar kind of orange feel to it, but it's missing the buddy or the friend aspect to it. And really that's what makes Cobb Buddy um, a more distinctive mark, is it's got that buddy aspect to it. So I don't really see griller corn as confusing too many consumers. How about corn cob skewers? Again, we're not really probably confusing folks because we don't have the the buddy or the friend or the acquaintance part of it. What about that bottom one? The color's a little bit different. And even the photo is different, but you've got to kind of look closely to see what the differences are. Probably more similarities than differences. What if you had that stamped on a product and you also had the Cobb Buddy logo stamped on a product? I think you're getting real close to a consumer confusion case there and a trademark infringement case if it's that similar. And so that's the type of analysis that you'll see when we're talking about the, the clearance work you can do, and also whether you want to enforce your trademark. Um, and I wanted to put this again. Be careful. Your competitors may be doing this same analysis against your mark, where it's flipped. Um, Maybe there's somebody out there called Corn Cob Skewers, and they've got an orange logo, and they're looking at Cobb Buddy, at my new product that I just released, and saying that's awfully similar. We think our consumers are going to be confused. They're going to think that Corn Cob Skewers came out with a brand new product, and that's Cobb Buddy, and that's a problem. So you can get a letter in the mail even if you have a registration, and that's an important concept to understand. Now, a common way to do clearance, and well, there's a few common ways. One is through a law firm, right? You can hire a trademark attorney to do a full clearance search. There is going to be some costs associated with that. One of the resources we use is just Google when we are doing clearance searches. There's a lot of other paid databases and other tricks and analysis we have when we're doing it. But you can go to Dun and Bradstreet Business Directory um, for and look up whatever the name of a company is, and sometimes you'll find that yes, there is one that looks awfully similar that also sells the same product. Sometimes not, or they're in a totally different industry. Like they sell airplanes, they don't sell grilling accessories. Um, you can go to industry websites too, and also look at retailer sites. For example, if you've got a new clothing product, it's probably good to do a quick Google search or Bing or whatever you use before getting too far down the line with investing in your mark. We'll go to the next slide. And this is pretty straightforward. You've got more leverage against infringers when you have a registered mark. You can really throw the book at them and come down hard with a registered mark in terms of damages, a federal lawsuit, or threatening a federal lawsuit. You can enforce in any state. Doesn't matter if you founded Cobb Buddy in Iowa or Illinois. If you've got a registered mark through the United States Patent and Trademark Office, you can typically just enforce in whatever state, wherever the infringer pops up. Common law marks, typically it's state level or regional. The damages are going to be a lot lower. So it's not going to, you can't say it's going to be tens of thousands or $1 million or something. With a state mark, it's going to be an order of magnitude lower at least. Um, Fewer options. So less less leverage is the bottom line here. But you can also get it for free. So next slide. So here's a quick overview. So we talked about what a trademark is, the difference between common law and a registered mark, and what it protects. It can protect words, like a word mark, just the words Cobb Buddy, or the words Seyfarth Shaw, or a logo. So for example, our nice black Seyfarth logo, or the nice orange Cobb Buddy logo. Legal budget to acquire, which is always going to be important when you're a startup and and you've got budgets for everything, is nothing. For common law, simply use it. But you get less protection. For registered, it's going to be on the lower end. Um, I'll give an example. Sometimes it can be around $1,000, sometimes less, sometimes a bit less, sometimes a bit more. Most of that goes into the costs of the filing fee that the U.S. Trademark Office requires. So that's a big component of that $2 sign there for the registered mark. Next slide. Okay, let's move on to copyright and copyright protection. So copyrights protect creative works that are created by whom? By an author. So think photographs, brochures, books, music, art, legal budget to acquire. Again, it's nothing for common law, but you have even less options for a common law copyright, as we'll see. Next slide. So the key concept here again is common law versus a registered copyright. A common law copyright, you simply write it, photograph it, you draw it. If your child, for example, my son goes to art class and he draws a picture or a painting, he's got a copy. He was the author of that drawing. He has a common law copyright on it. Now, what do you get out of that? As we'll see, it's not much because you can't enforce it in federal court, and there's no real good mechanism for enforcing it in state court like there is for trademark law. So let's go right over to registered copyrights. A registered copyright, it's similar to a trademark and it's similar to a patent, registering those. You file an application with the U.S. Copyright Office and you can register the text of something. So if you've got a brochure as an example, or a book, you've registered the copyright on the whole text, and whatever that is. You cannot register copyrights on slogans. So that's an important distinction. The text has to be something more substantive, like a book or a brochure or an essay or something like that. Photographs, very common to register copyrights. There's a lot of good ways to do it too. A lot of different mechanisms the Copyright Office has to register many of them at the same time for a cheaper fee, which is nice. Drawings, website content is a big one. This is one important thing I want to talk about too, because you're probably going to see this. You may have already if you hire somebody to create content for you. A work for hire, what does that word mean? The problem is there's two meanings. So in the let's just go with the basic meaning for most folks in the public. A work for hire is something where you hire somebody and they create something for you, and you buy it from them, and you own it, right? In the legal context, it's different. A work for hire is a very specific type of authorship. So let's use a photographer as an example. Let's say you are a newspaper journalist, you're employed by the newspaper and you go out and take photographs. Technically, when the newspaper files the application with the U.S. Copyright Office to register those photographs, the newspaper is the author. The photographer would not be the author in that context. The newspaper is the author because they are the employer and they hire that employee, the photographer, to go snap photographs for them. So it's important to know that if you hire somebody, oftentimes it's as a contractor, it's not as an employee, and so it may not be a work for hire, and that's okay. It just matters how the contract is written up. They would assign the copyright over to you rather than you being the author as the employer, or as the contractee. So it's a very subtle difference, but it's important to know this. for when you deal with pretty much any freelancers or contractors who are not going to be formal employees of your company. You're going to have to get an assignment from them or a license. The designation, so common law registered, put the C in the circle on it. You don't need a registration to do that. And we've got our examples there that we already talked about. Marketing collaterals is a big one. So oftentimes when we file applications to register copyrights, it's for marketing documents and photographs related to marketing. So next slide. So let's dig a bit more into acquiring a copyright. And if you hire someone to create the work, you've got to have an agreement. It's a real bad idea to go out and hire somebody without getting something in writing. And there's two main types that we touched on briefly: assignment and a license. An assignment states that the person is assigning right, title, and interest. Sometimes you see entire right, entire title and interest in a copyright to a company. And what this is like, it's like a deed. I'm going to use a housing example. When you buy your house, that's similar to what an assignment is. You lose all the rights in it, or you're paid for it. You're buying it. You buy a house and you've got everything. You got the locks, you got the keys to get in, and importantly, that previous owner is exactly that previous owner. They can't get in to your house anymore and never will be able to, because they've assigned the whole thing over. Again, getting back to the work for hire, we've got some notes on that below. So we would suggest, and we always look for this when we review contracts relating to copyrights, is to make sure you've got it right about work for hire. I would delete references to it, or if it's not used in the correct context. So be very careful about this. The employer is the author if work is by the employee who's on the job. If it's a third-party designer, that person's the author, and then it's as straightforward as that. A license is the other way when you're acquiring copyrights, and you might see this sometimes more with I found with artists, because they've been taught and probably by good lawyers who tell them this: don't assign over your art. A license document states that a company is a licensee of the copyright. Analogy to real estate, it's a long-term lease. You don't own it, but you're the licensee. You can get into it. You can use it however you want. If it's exclusive, you're the only one who get in. So like if it's like an apartment building or something, or an apartment, you've got full rights to it. You can always get in. If it's non-exclusive, that means other people can also get in. So it'd be kind of a strange situation if everybody was using it. Sometimes you see this with stock photos a lot, where it can be non-exclusive. Go to the next slide. So the key concept here for enforcing a registered copyright is that it's really the best value for IP protection that's available. They must be federally registered for enforcement, but enforcement is very cheap. But registration is very cheap. You can see that on the right there. Registration for electronic filing, if you've got one author, one person who says that they own it, and one work, I mean, under $50. It's very cheap. And sometimes for those, it's got all other filings clumped together. Sometimes for those, you can put multiple works in, like the photography example I was talking about. You can put a whole bunch of photographs into one single filing, and you can acquire a registered copyright through that one filing. So and then there's a couple other examples down there too. Paper, you can file in paper. Usually, there's no reason to do so, but that's an option. And then there's options of as unpublished versus published already, and the price varies on that. But everything is, I mean, well under $200. So, and most are under $100 even. Um, with that cheap application fee, you are able, just like a registered trademark, to really throw the book at somebody and bring a federal lawsuit and get damages, or try to seek damage. You can try to seek a lot of damages with a registered copyright. The way I think about it is who is out there who's helping create and write the copyright laws, and it's people who have very valuable people in companies who've got very valuable copyrights. And just a little chart there that I pulled from Wikipedia, written up by a law professor, and you can see how the copyright extension has, well, it started off with these particular years, and then these ones were tacked on, and these years were tacked on. It keeps getting longer and longer and longer, and it's good for folks who have registered copyrights. So you can do a good job protecting your copyrights. For the next slide. And here's an overview here. So we've looked at protecting creative works, examples of those. Our examples, again, were the marketing collateral, and then legal budget to acquire. And you saw what those registration fees are, to apply to register, well under $200. And you get a law, you can get a federal lawsuit out of that. Next slide. Okay, so we're going to talk about patents next. And what patents are, there's two main types of patents that we're going to talk about. There's no common law patents, importantly. Unlike trademarks and copyrights, you can only have an issued patent. You can't just get a patent just by using something. You always have to apply for it. The two main types are design and also utility. And with the design, as we'll see, it really is a design of what something looks like. And then for utility, this is more what people typically think about in the patent context. It's an invention, it's a machine, it's something that works. So go to the next slide. So a utility patent, you can see on the left there, protects a machine. Uh, Also, some people don't think about, it can protect a process or a formula, kind of a way of doing something. And so this example here, what we've got is, we've got our protection, our patent. We filed a patent for Cobb Buddy, a utility patent application, and we're hoping to get it issued by the U.S. Patent and Trademark Office. It's the same office that you file to register a trademark in. And we've got a special formula there. You can see it on the bottom left there in that flask. We put it on the skewer, and when you use that skewer for Cobb Buddy, and the corn is perfectly done, it turns from gray metal to yellow. And so you can file an application for a patent on that formula or on that product. Or maybe you have some type of machine or some way of applying that that formula to the skewer in the first place, and you could file for a utility patent on that too. Now, a design patent, completely different. It has nothing to do with how the thing works. Nothing. All it does is protect how the product looks. We call it an ornamental aspect of the product. Ornamental means just simply how it looks. It's got to be novel, just like utility patent. So it's got to be new, and nobody must have thought up of again. And I've actually found one. online. It's called the kebab skewer. So we'll see. It looks like it's got kind of a golf flag sticking out of it. We'll go to the next slide. And here are some design pattern examples. And I skipped over the Cobb buddy example, but it's kind of had that metal plate to it. Here you can see it's a dress, so it's got a zipper going up on the side, some buttons on the top, and that is something you can acquire a design patent on. A shoe is another example. Um, so you can see the different design features of the shoe. It's got those lines in the middle, and they're kind of intersecting, and that's something that you can get a design patent issued on. One of the important things I want to talk about is you can see the dotted lines. It's more on the shoe that you can see it. Most of the shoe has these dotted lines around it. That means that portion is not protected. So really, as an examiner, if you're deciding whether this design is novel, you're an examiner at the U.S. Patent Office, you would just discard all of those dotted lines, and you really only focus in on that design right in the middle with those intersecting lines. Here's another one. This is called, and I put the title below there, and this one on the right is called Retail Package for Wearables. So this is kind of like a display case for when you, but also product packaging. So a display case and also product packaging in one. It's just how that looks. They didn't come up with the first, you know, transparent display case that you can also buy, but they did want to protect exactly how that looks. So we go to the next slide. The advantage with patents, one of them is very high damages potential. And as we saw with trademark, or really with a registered trademark and a registered copyright, that gives you leverage against an infringer. Because when you get a demand letter or sure enough, service of a lawsuit in the mail, saying that you may owe upwards of $1 million and these statutory, punitive, and oh, by the way, we're going to be in federal court. That can be scary. That can be scary to an infringer. And so that's what we're talking about with leverage. With a utility patent, the infringer, they could have entire product lines that are liable. So when you look at it from a business perspective, maybe they only have one product line. So your entire business, the entire way you do your business for that infringer, they could be on the hook for that. So it goes to it can really go to the root of their full business. They can owe triple damages and also attorney fees if they lose. So it's an additional incentive for an infringer to settle or just to stop what they're doing. Because if you lose, if you roll the dice and you end up losing, you could owe 3 times. And also, whoever the attorney was that the patent owner hired, you could end up paying their fees too, as well as your own attorney fees. There's some special law too where you can a court can actually order an infringer to stop and block any import. So they work with the U.S. Customs Force to block any ships coming in and block any cargo getting unloaded for the infringing product. The issue really is though that the cost is very, very high. So usually it's way too costly to try to go after an infringer. However, there are some exceptions, and there are a few important ones here that I want to talk about. One is you can hire a lawyer on contingency. This is very common with patent cases. So it's just like a typical contingency civil suit. They will take a certain percentage, depending on a settlement or if you win, and if you lose, typically it's just nothing. So also litigation financing investors, because of all that high damages potential, there are investors that are interested in fronting the cost of a patent lawsuit. And you can find them if you look online and call around and ask for some reputable litigation financing companies. Usually they will have a patent division that they can take a look at your case. The other option is you can sell your patent. So once you get your patent, they're pretty easily transferable. And so you can say, well, here's the assignment document, and go ahead and buy it, and then that company will enforce it, and they may pay you more if they think you've got a good case on hand. So go to the next slide. So here's a quick overview of what we've seen with patents. So you can protect inventions, gadgets, machines, chemicals, formulations, all kinds of things like that. And some real world examples: a selfie stick, sewing machine, hand cream compositions, or hair, or skin, or anything. A door stop, right? That's one I was looking at recently online. And our examples with the Cobb Buddy was there were really two examples there. There was for the utility patent, we applied that special formulation so that it turns yellow, and then with the design patent, we have this kind of cool gray textured look to it in both the before and after cooking version of the skewer. And we've got the legal budgets to acquire there. The utility patents are quite expensive. Just to give a very broad range, and everything's fact specific, but it could be between $10,000 and $20,000 for a utility patent. For a design patent, again, a pretty broad range, probably between $2,000 to $3,000. So it's a very significant cost difference, design versus utility. Unlike with trademarks too, a lot of that cost is going into the attorney time, especially with utility patents. They're very time consuming to draft and to really get the full protection that the invention deserves. So we'll go to the next slide. And we can go to the next slide. So we're going to talk about trade secrets here. The key concept with acquiring a trade secret right there at the top, it's got to be commercially valuable, known to a limited group of people, really on a need to know basis. Doesn't have to be like a top secret basis, but really a need to know. You're not just telling everybody. And it's subject to reasonable measures of protection. We'll talk about what that means below. So some of the examples are design patterns for clothing. So if you've got almost a cutout or a series of cutouts that you use with fabric, that's a great example of a trade secret. You're not going to go and publish those on the internet. You may not keep them in a safe, but you probably would keep them in an office, and it would be a locked office, and it'd be a problem if they were stolen, because they're commercially valuable. If that's the way that you're cutting your fabric for the product you're going to sell, then that's the type of commercial value you need to show for a trade secret. And some of this is sort of like a common law trademark, like we talked about, where if you start using it, you can get some value, maybe just from that first time. But as you build on that trade secret and that common law trademark over time, it gets more and more and more valuable. So formulas and recipes, perfect example would be the Coke formula, right? And supposedly that one really is locked in a vault in Atlanta, and it's very much on a need to know basis. Perhaps nobody really knows, even at Coke, the full recipe. Maybe they just only know parts of it, and it's extremely commercially valuable. One of the key parts of trade secrets when they're useful is that it's very difficult to reverse engineer them. So sometimes I'll give an example with a patent. If you patent a chemical and you're selling that chemical out and about everywhere, well, somebody can take that to a lab and they can figure out what the chemical is at some point. It may be a little bit more difficult though, with some formulas and recipes. We're doing a lot of different chemical processes in between the raw ingredients and the final product. And so that's a good use of trade secrets because uh, nobody can reverse engineer it. Customer list is another very common one. If you've got 20 customers in a list, if you've got 10 customers in a list, something that's typically it's very valuable. And what you see in a lot of cases is that when people leave their employer, they can sometimes take those customer lists with them. We see a lot of lawsuits over that. Computer code is another example. Think about the Microsoft Windows code. It's certainly commercially valuable. Um, it's very much on a need to know basis, and it's not published online. You can't just go and find it. So moving to the right column here, um, the decision to retain and protect trades. Why would we use trade secrets over other forms of IP? One of the most basic ones is our IP is just too costly. Cost too much. Trade secrets are free. You don't really get a nice registration in the mail or something like that, or an issuance, but they are free and they do give you some protection. It may also not be protected by other IP. So perhaps it's not patentable. Maybe it's not new. It's not a new recipe. Think about restaurants. You've got a great new recipe for lasagna or something like that. It may not be patentable. It may not be new enough to be patentable, but you can sure protect it with a trade secret. Um, it may not be ready for public salience. You should be able to keep it in the research and development mode, um, and you could get some more revenue in the long run. So with a patent, when you get a utility patent, you will reveal, you're required to reveal by the U.S. Patent Office exactly how you make the thing. So using the Coke formula or design patterns as an example, you would have to explain to them exactly why you cut your design pattern for the clothing in this particular way and why that's advantageous. And it's all going to be out there for the public to see for years. And so you, after that 20-year period of when you have patent protection, you will stop receiving patent protection, and anybody can read that patent and replicate it. Not so with a trade secret. You could have that same pattern. If it was a popular one and nobody could figure out how to reverse engineer it, you could have it for 100 years, say. So let's look at the Cobb Buddy formula for yellow skewering. And we made one of those decisions, probably the first one. Probably other IP it's just too costly for this type of product when it's starting up. And so what this is it's the formula for the yellow skewers. So previously we'd acquired a patent on it. In this case, we're just going to keep it as a trade secret. So we're going to write down what that formula is in our office and keep it behind a locked door. And it's commercially valuable because it's the whole basis for our marketing for the Cobb Buddy product. And only select employees need to know about it. We're not just telling everybody. We certainly don't want somebody to run with that formula and start up their own business that competes with Cobb Buddy or take it to a competitor. Next slide. And so, how do you enforce a trade secret? So usually it's against a former employee, and this is the example that we had with customer lists or with computer code. You do a copy paste of an Excel spreadsheet or a Word document or something, and all of a sudden you have that one single page, which is so important for the business and enables somebody else to leave your business and to start up a new one. Usually what you've got to do though is prove protection. So if they could say, Just to use the customer list example, they could say, well, you advertised that you worked with these 20 customers already. It's right there on your website. I'm just making this up. And in that case, you may have given up, abandoned, or waived your trade secret and just totally given it up. And now that person could rightfully leave, only in this narrow instance of a trade secret and start up, because they could say, well, you never kept it a secret. So it's usually cheaper than other forms of IP to enforce, especially compared to patents, and compared to trademarks, and copyrights can be very expensive to enforce too. There is strong law for getting a very early court order. Like, for example, if somebody quits on a Friday and they're going to start up their competing business on a Monday against you, and you think that they've got your customer list, in some cases you can go down to the state court and you can get an injunction pretty early on. It's almost like an emergency hearing. Head into the court and put a stop to that. So that's frequently what you see in cases like this. You can also go into state or federal law. Traditionally, it's state law, which deals with a lot of trade secrets, but it's increasingly becoming federal court based because of a new federal statute protecting trade secrets. So, just to give some examples of the reasonable protection, electronic computer security is something you can tell the court if you're trying to prove protection. Well, that Excel sheet, you had to log into our private computer system, which required a password and a login, which we as the employer give out. Documents confidentiality agreement is a real good one. So on your first day, Mr. and Ms. Employee, you were supposed to sign this, and you did, and by doing so, you agreed that we were going to give you trade secrets, and these particular trade secrets, and we gave them to you. And then physical lock and key. So that's like the Coke formula example. You literally put it in a vault, but this can be as simple as just locking it in your office. We go to the next slide. So just as a overview of trade secrets, it protects. What does it protect? It's secret information, and examples are formulations. Here I've got some new L'Oreal formulation, or the Coca-Cola recipe, and our example with Cobb Buddy was the special formula that you put onto the skewer so that it turns yellow when the corn's done. And we decided that was going to be a trade secret, and we weren't going to file for patent protection on it. Perhaps because patent protection for that would have been too expensive, and because maybe because we can get more protection in the long run out of it. If we don't tell anybody, we can get longer than patent protection, which only lasts about 20 years or so. Legal budget to acquire is none, but it's important to pay attention to those other aspects to prove up protection. So that would require some cost. For example, there's some cost to getting confidentiality agreements. There's some cost to setting up your IT system so that it's secure. You could argue even there's a cost to putting a lock on the door. So next. And so here's everything. So we'll do a real brief overview here of what we talked about. So trademark can protect words, and they can protect symbols, brands, and logos is really what you can use trademarks for. We've got our example of the Cobb Buddy, and importantly, we've got the word, what's called the word mark, Cobb Buddy on the right there, and also the bigger logo on the left. And likelihood of confusion can be compared for infringers between either the word mark or the logo. And remember, folks can do it. Competitors can do it against you too. They will be comparing your product to see if it infringes, whether you have a common law mark or a registered mark or not. Copyrights are protecting our creative works here. For Cobb Buddy, we used a copyright, we registered for a copyright using those cheap filing fees to protect our marketing collateral, including our photographs, our product photographs, so that nobody could use those. without our permission. And we're very careful when we're retaining folks to create those images that work for hire was used appropriately, and that if we were just going with a freelancer who would take a photograph with for us, who was not an employee, that person was the author, and it was not the company. But if it was an employee, then it was going to be the company. Um, and folks, you can look at some of the copyright circulars on this if you want a quick reference to this concept. The Copyright Office puts out a lot of great publications. Just go ahead and Google them. They're a little more detailed, legally detailed than what we've talked about here, but they're still written with a real basic eye to how copyright registration and enforcement works. So again, we used our cheap application fees to register photographs and marketing collateral for CopBuddy. For patents, again, they can protect inventions, or they can also protect designs. So design patents and utility patents. Utility patents are a lot more expensive than design patents. Here we've got both the utility and the design patent example with CopBuddy. For the designs, it's kind of those cool lines on the skewer, and then for the utility patent part of it, it's switching from the gray metal to the yellow when the corn is fully cooked. And then finally, trade secrets, which we just spoke about, protect secret information, and that's commercially valuable. And our example there was in the trade secret example, we decided not to patent the color change in skewer, or rather the chemical that changes the color of that skewer. And so we just decided to keep that as a trade secret under lock and key and on a need to know basis. And there was no legal budget we had to pay for that. Next slide. So thanks folks. That's all, and really hope you enjoyed the presentation here, and that you have the tools now where you can speak to an attorney about this if you need to protect your intellectual property, and help to make your decisions about whether and how to protect that IP. Thanks, everybody.
Thank you for joining us for this session of the Citi Cares Small Business Academy. This presentation has been prepared by Citi Trends and Seyfarth Shaw for informational purposes only. The material discussed during this webinar should not be construed as legal advice or a legal opinion on any specific facts or circumstances. The content is intended for general information purposes only, and you are urged to consult a lawyer concerning your own situation and any specific legal questions you may have. Please leave any questions or feedback in the comments section below. For more helpful links and more episodes, please visit the Citi Cares Small Business Academy YouTube channel.